Thank you so much, Councillor Washington. Um, and thank you so much for the attendance. I hope it's going to be an enjoyable session. To begin with, I'm going to share the screen and my presentation for today. So, the topic for discussion today is about sorry, I'm just trying to minimize this. Yes, the topic for today is about what kind of recourse can the peoples in the developing countries have in circumstances in which the interventions of either the World Bank or IMF or generally international financial institutions, in circumstances in which those interventions harm people, what legal recourse may the people possibly have, and whether these recourse are legally tenable. So I look at it in two ways, that there could possibly be two ways in which the peoples of the third world could challenge or counter the harms, the violations that development may cause in their various countries. One of them would be strategic litigation, and the other one would be litigation before these institutions themselves. For example, the World Bank has got what we call the inspection panels. The African Development Bank as well has got their own inspection panels. To begin with, let's start with strategic litigation as the push, in my view, that those who may wish to sue the World Bank or IMF in this country or elsewhere in other jurisdictions always look to strategic litigation as a push to realize development justice. There could possibly be other other mechanisms for realizing development justice, what I call the extra-institutional forms of mobilization through social movement practices. In this, you can see the way the Ogeeks, the people of Turkana, are resisting, if not only against international financial institutions, but also the interventions of transnational corporations. Africa, as a way of also resisting, which could be through its own generational production of knowledges, such as in the past, African socialism. The idea of the right to development, of course, is germane in an African idea. Another mechanism is participatory accountability. In my view, I think strategic litigation that has emerged in the recent past against the World Bank and IMF in various jurisdictions, and I will give you the evidence in the next 1 minute, seems to be an expression of the global expansion of strategic litigation as a form of what I call third world subaltern resistance. Here by third world, I mean I'm using the word third world not in the derogatory sense, but in the as an analytical category to define people who share a common experience. So it seems to me that strategic litigation is part of a radical call to transcend the existing limitations or challenges. For example, the question of jurisdictional immunity. You are all aware that suing the World Bank in any national jurisdiction is barred or precluded by procedural or jurisdictional immunity, if not functional immunity. So the evidence is there. The evidence is already there, and the first evidence of people suing international financial institutions emerged in the US in the case of JAM versus International Financial Corporation, IFC. These were poor farmers from India, fishermen from India, who decided to sue the IFC. IFC is the arm of the World Bank that deals with private lending to private institutions. So in this particular case, they financed a project that harmed people in several ways, and the people were able to file that case in Washington District Court, and they challenged the decision, the various harms that were occasioned to them, as we'll see in the next few minutes. There are cases, of course, where, even though not directly, like remember, we all recall the Greek economic crisis that caused a great deal of challenge. That was before the European Committee of Social Rights. And there's a case whereby people sue the United Nations as a form of international organization, if not an international financial institution, for the spread of cholera in Haiti. And you can also see there are also, if you look at the World Bank inspection panel, you see quite a great deal of cases being filed there that are challenging the various ways in which the development harms the indigenous communities or other people. There's a case of Rodriguez versus Pan-African American Health Organization that we will see very briefly. So there is already a great deal of evidence depicting heightened litigation against international organizations or transnational corporations across many jurisdictions. And this emerges in India, Malaysia, but particularly in India and Latin America. So it's an urge to Kenyan lawyers and practitioners that there could probably be new terrains for litigation that we need to explore. Now, the question of litigation before and against developed institutions has enormously expanded or gained traction since the 1990s. And of course, for some of us who recall the structural adjustment program that started from somewhere in the 1980s and continued all the way to the 1990s, and has still much replicated even in the development programs of these days. So there was always an impetus to encounter or to counter the intervention of these institutions. The quest for development justice has always been there. Of course, the other reason why the litigation has grown over the years is that there's often a conflictual interaction with the various kinds of models of development that these institutions advance. And these contestations, some of them are always geopolitical or geoeconomical. The other reason why litigation has gained traction is that the dominance of these institutions in terms of the technical assistance that they give to these countries, the surveillance, advisory facilities, and lending, which have got more consequential asymmetrical structure, which portrays more of a asymmetrical structure of the global policy systems, shows to these people that there could be other ways of fighting the dominant system through litigation, if not through participation within the executive boards of these institutions. The other reason why litigation has grown, in my view, is that the production of technocratic knowledge by these institutions in itself has meant that the development practices of these institutions have become so predatory. So in several ways, for example, the conditionality regimes, the structural adjustment program that I've just mentioned, the austerity measures and so forth, that causes a great deal of hindrance on the people of these countries. The other reason for strategic litigation, as you can see, is that the ascendance of the neoliberal creed and the subversion of the development aspirations of a majority of the people living in the global south has been central reason or impetus why the people need to challenge these institutions. For example, as we can already see, the acknowledgement by the United Nations human rights policy system that recognizes that when there are significant gains to be gained from liberalization as a result of structural adjustment programs, such reforms do not provide the best outcome for all. There are always people who are always left behind or left in the cold. The experience of the last 20 years, there was a report in the 1999, in Africa and Latin America shows that structural adjustment policies are not consistent with long-term development needs. Now, because of this recognition, and I think as we all recall, the resistance movement that arose from the 1980s in countries such as Egypt, Sudan, and so forth, was an expression of the people's resistance to the intervention of these institutions, and expressions of resistance to the pauperization of the administration of these people, but the various structural programs of these institutions. So that is to say that if we are going to look at how to challenge these institutions, what would be the cause of action? The cause of action would be, for example, most of the programs that are human rights retrogressive would be some of the challenges where we need to target our litigation, strategic litigation. So that my argument here is that the push to realize development justice has arisen over the last 30 years due to the intensification of human rights deprivations and escalating development injustices posed by the predatory development policy system. I hope up to that end, we have clearly highlighted the reasons why litigation has become very crucial for people living in the global south. So two forms of strategic litigation. You can sue the World Bank or IMF directly, either in Kenya or in Washington, D.C., and I will explain the reasons for that. Or we can litigate cases of communities that are affected by development in various areas before the adjudicatory panels of these institutions. Straight to how suing the World Bank or IMF has worked in other jurisdictions. So this has happened in the United States of America, as I said, where farmers and fishermen in India, in Gujarat in India, brought a case challenging the various violations in the funding of the design and the implementation and the funding of the project in India. So, but again, that case faced a legal challenge, the traditional question of procedural immunity from judicial proceedings. If you look at the founding documents of these institutions, whether it's the World Bank, International Development Agency, or IMF, or even the UN Charter itself, there are functional immunity and then a procedural bar from a procedural bar or a jurisdictional bar bring a case against these institutions. So immunity is always an express bar to holding international financial institutions accountable in national jurisdictions. Of course, the only exception is when these institutions waive any suit against them. Now, but the United States Supreme Court has since ruptured that classical absolute immunity jurisprudence. As we recall in international law, the principle of absolute immunity often was classically justified by the functional necessity, the Committee of Nations, and sovereign equality. But I think in the case of JAM versus International Financial Corporation, these totalizing conceptions of absolute immunity has been dethroned. So in the case as we are just about to see, the Supreme Court overturned the jurisprudence of absolute immunity of international financial institutions through a new legal technique called restricted immunity exception. And for that reason, I think there is ground. Kenyan litigators, practitioners, jurists should now see that we could probably transplant the case of JAM versus Rupture. So this is a case, JAM versus IFC. As I've said, International Financial Corporation is an arm of the World Bank that deals with private lending. The other arms are International Development Association, International Bank for Reconstruction and Development, and MIAGA. So in this particular case, fishermen, as I've said, and farmers who are residents in India and other local communities brought a case before the Washington District Court. The case sought to hold IFC accountable for property damage, environmental destruction, loss of livelihood, and so forth. Of course, IFC had already recognized that its project, or the project that it funded, had potential significant adverse social and environmental impacts that were diverse, irreversible, and unprotected. So when the case came before the district court in DC, the question was, the first question, of course, was jurisdictional, that jurisdictional bar, the immunity of international organizations, whether or not they could be sued before the United States court. Part of the reason, or the main reason why the case was filed in the US is that these institutions are domiciled in the US, they are headquartered in Washington, D.C. So most of the cases that you will see will always be D.C. court cases, or D.C., what they call the D.C. circuit, that is their court of appeal. So the D.C. court dismissed the plaintiff's case based on a binding decision of the D.C. circuit, the appellate court, that had already held that international organizations enjoy absolute immunity under the act. There's a statute in the US called the International Organizations Immunities Act, I think of 1970 something. The court, of course, went to appeal, and the district court circuit affirmed the court's decision of absolute immunity. Now the question went to the Supreme Court, and the question was whether international financial institutions, IFC in this case, enjoys absolute immunity under the International Organizations Immunities Act. Now, what happened is that act, previously, there was Foreign Sovereign Immunities Act that also provided that that state immunity, absolute immunity, could be waived in circumstances where the state descends into the commercial realm. So anything non-commercial, states could not be sued in the US. But the the Foreign Sovereign Immunities Act had been amended to bring that exception to absolute immunity jurisprudence. But in the International Organizations Immunity Act, it referred expressly that the same immunity that states enjoy is coterminous with that which international organizations enjoy. So the question before the Supreme Court was whether international financial institutions enjoy absolute immunity. Now, the exception was applied by the Supreme Court. So the Supreme Court stated that international organizations enjoy the same immunity from suit as is enjoyed by foreign governments, except to the extent that such organizations expressly waive their immunity. Now, the Supreme Court was relying on Section 1605 of the Foreign Sovereign Immunity Act that provided, because I've said the Sovereign Immunity Act was to be read together with the International Organizations Act, which made it express or made reference to the Foreign Sovereign Immunity Act, that commercial activity exception applies to states. And so in such circumstances where a state descends to the commercial realm, the veil of absolute immunity will be applied. So this is the case of the restrictive immunity application. Now, in that section, it was provided that there's an exception to absolute immunity of the state under the Foreign Sovereign Act, and therefore applies to international organizations in circumstances in which the action is based upon a commercial activity carried on in the United States or upon an act performed in the United States with connection, in connection with a commercial activity of the foreign state which is conducted elsewhere. This is like splitting hairs, and of course there's a third exception. Now, this is the section that the Supreme Court read to make a finding that international organizations can actually be sued for their harms, for their violations, for tortious activities that happens elsewhere. But there is a catch. The legal test that the Supreme Court applied is that it must first of all be a commercial activity, and the commercial activity must be carried on or performed in the United States. So this is where the question of nexus, the Supreme Court call it the substantial nexus to the United States. That is the case of the cause of action or the conduct or action giving rise to the suit must have a substantial connection to the United States, and it must be a commercial activity. So the suit must be based upon that conduct which has got a commercial nature. So the case was remanded back to the DC court to determine whether the facts of this case met the Section 1605 requirement of the Foreign Sovereign Immunity Act that applies to international organizations. Of course, in that case, the DC court now, the court with original jurisdiction, found that while IFC failed to ensure that Tata Mundra power plant, designed, constructed, and operated with due care so as not to harm plaintiffs' property and health, the plaintiffs had failed to prove that such conduct of IFC, their failure, to exercise due diligence in the design and construction and operation of the power project, did not have any substantial connection to the United States. In fact, the court was saying that harm, the harm complained of did not happen in the US. It happened elsewhere in India. Now, so that is the precedent that the Supreme Court has established, that you can actually sue international financial institutions, even though these institutions enjoy functional and procedural or jurisdictional immunity that expressly bars bringing any litigation against these institutions. Now, I think that should set us thinking as a country, or as lawyers in this country. Of course, recently we have had complaints against the International Monetary Fund when they were entering into lending negotiations with the government of Kenya. And there was all those flurry of comments on the IMF website. But I think this is a call for lawyers in this country that indeed there are new fertile grounds where we can conduct litigation. We can sue these institutions actually. In the United States, for conduct that, or for harms or violations that occur against the people in this country. JAM versus IFC has been followed in Rodriguez versus Pan American Health Organization. In this case, I think the complaint was that Cuban doctors, this same question of lending doctors to different countries, the Cuban doctors were lent to Brazil. And the arrangement was that they will be paid by this Pan American Health Organization that will process their payments. This Pan American Organization is an agent of the World Health Organization. Therefore, it also enjoys immunity in the same status as the United Nations, IMF, or World Health Organization. It's based in the US. Now, but they process their payments. So the case was that Pan American Organization facilitated slave labor of these doctors. So they went before the Washington, D.C. court and sued the Pan American Health Organization, irrespective, despite the fact that they enjoyed immunity. And of course, the court agreed with them that one, the commercial activity in this case was the processing of the payments from Washington, D.C. to the Cuban government to pay these doctors. And I think that should set us thinking that we can actually sue international financial institutions in cases where they cause harms to the various people through their programs or through their policies, through their structural reform measures, the austerity question. IMF conditionalities are still very much part of international development practices or international lending practice. So I think when one needs to sue these international financial institutions, the tenability of that should be based on those three factors. The suit must be based on the fact that the harm, the activity that has caused the harm is a commercial activity on the part of an international financial institution. It has either been carried on in the United States or performed in the US. And that's what they call the nexus question. Now, the challenge, which I think is still very much right, is how do you prove, or how does one determine a commercial activity? When an international organization descends into a commercial activity, into the commercial realm, what is the definition, what is the nature of a commercial activity? And the definition actually is provided by the Foreign Sovereign Immunity Act of the United States. It just says that the commercial character of an activity shall be determined by reference to the nature of the course of conduct or particular transaction or act, rather than its purpose or motive. Now, but in the United States case of Weltover, the definition has been provided of what a commercial activity is. So a commercial activity should be something that's outside the sovereign powers of the state. Of course, international financial institutions are not engaging in sovereign powers. They engage in private conduct, private contract with states, with its private institutions, and so forth. So the case defines commercial where it exercises only those powers that can also be exercised by private citizens. So the criteria here is that if a state descends into the realm of such conduct or character, or acts which would otherwise be done by private citizens, then it meets the definition of what commercial activity is. Now, that should set us thinking. If, for example, one wants to sue the World Bank or IMF for lending to Kenya, on ground of structural reform measures, which austerity measures, of course, for example, poverty. And this is very well known. The literature is out there that the austerity measures, the structural reform measures that the institutions always profile or recommend to states causes more harm. They are human rights retrogressive. They cause poverty. They can cause the cutbacks on social spending. For example, in the case of Sudan, something that is not very much well recognized is that the overthrow of government was as a direct result of the people's agitation against the cutbacks or subsidies on bread, or even subsidies on fuel in Kenya, for example. It may be assumed that ordinarily the activities of international financial institutions are of a commercial nature because this is lending. That is not the case. I think the question has been determined by Welch over that. Lending, sovereign lending between international financial institutions and an international organization is not necessarily a commercial activity. That's what the Supreme Court has decided. But I think that it depends on how one frames their argument before the court. Of course, the question whether it's legally tenable to sue an international financial institution for harms that happen in another country in the United States is possible. It is tenable, in my view. It can be done. Of course, some jurisprudence exists out there against this question of absolute immunity. Olivia Dispute has argued that a suit based on alleged violation of human rights universally recognized should not be treated as having a disruptive effect on the functions of international organizations. So the question of disruption or bombardment of international financial institutions with suits was actually before the Supreme Court in JAM versus IFC. So I think the Chief Justice, who was the author of the judgment, said, while that may be the case, but remember, it's not in all cases that the lending activities between these institutions are going to be of a commercial nature. So I think what JAM versus IFC emphasizes, I think the legal classicals here, is that jurisdictional immunity is not necessarily a blanket rule. So for some of us who may be aggrieved by IMF's interventions in this country, for some of us who may not like the World Bank, the outcome of World Bank funded projects in the circumstances where they harm people, there is recourse for litigating against these institutions in the United States. Of course, there are so many cases that are coming from the European Union that emphasizes that human rights are the fundamentals of the international society. Therefore, these technical rules may not really trump the jurisdiction, of course, to determine these cases. Now, in my view, I think JAM and Rodriguez's case against Pan American Health Organization offer crucial insights necessary for walking a new terrain in the struggle for social justice from a southern perspective, from a developing country's perspective. In my view, again, the dethronement of restrictive immunity theory provides a new and unexplored terrain that the Kenyan bar can engage with as a way of spreading the net of accountability wider and expanding the emancipatory struggles for the people in the global south. Now, in another thing, a third point that I want to make in connection with the JAM versus IFC case, that strategic litigation in the area of socioeconomic rights in Kenya should begin to focus on international economic institutions. This is what Kenyan lawyers haven't done. In India, it has been done. In Southern American countries, it has been done. In Malaysia, actually, people have sued UN persons who enjoy immunity in the case of Kumaraswamy, and the court has ruled that they have jurisdiction. So whenever we will be facing any grievances against IMF, I urge lawyers to try their chances before this court and raise this question of procedural immunity. So in my view, international economic institutions should be new focus of strategic litigation because these institutions always champion policies and structural measures that engender and perpetuate gross socioeconomic rights violations. So let us look to Washington, D.C. Let us take the battle to Washington, D.C. Let us go and occupy Washington. with these cases that seek the emancipation of people in the third world who are always the victims of development interventions of these institutions. Now, I said there are two dimensions to strategic litigation against international financial institutions. It can be before courts, or it can be before a national court. I think I've lost a slide somewhere where I was going to argue the case for litigating in Kenyan courts. I think in my view, we can take these institutions to the Kenyan courts, and when the question of this procedural bar is raised, the absolute immunity of these institutions, the response can always be that the Constitution of Kenya is supreme, and that any law that offends the Constitution is to that extent null and void. Remember, international law becomes part of Kenyan law. International law, international standard become part of Kenyan law. Now, human rights are also sacrosanct. You know, the Bill of Rights is also very sacrosanct. So any person or any law is subject of the Constitution. So institutions, international financial institutions that are domiciled in Kenya can be sued before Kenyan courts, irrespective of the fact that they enjoy functional and jurisdictional immunity. That question of jurisdictional immunity cannot trump the fundamental rights that are provided for in the Constitution, in my view. We can have this argument at the end of this presentation. Now, we can also litigate against this institution before their own adjudicatory panels, or their own independent adjudicatory panels. So the World Bank, for example, has got what we call the inspection panels that applies to both International Bank for Reconstruction and Development and International Development Association. And for the International Finance Corporation, IFC, they have what they call Compliance Advisory Ombudsman. So the case JAM versus IFC actually was, before the case went to the US Supreme Court or the US court, it was first of all filed before the IFC ombudsperson or ombudsman. Now, the history of the inspection panels is that from the 1980s, there was a great deal of agitation for reform of the way the World Bank does their business. There was a lot of massive outcry and intense protestation against the bank's lack of transparency, accountability, and responsiveness in relation to project financing. Particularly in India, I mean, that's why I want us to borrow some jurisprudence from India, where strategic litigation, including social movements, resistance against international financial institutions and transnational corporations, is very, 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 very strong. This is what in Kenya we call public interest litigation. Now, the Indian Narmada Valley project is actually what led to the creation of the creation of the World Bank inspection panels that have since been replicated by all these international financial institutions, African Development Bank, Asian Development Bank, and so forth. There was also what we call the Wapenas report of around the 1992 that pointed to the culture, what we call the approval, the pervasive approval culture, in which the World Bank was more interested in lending, the number of lending, as opposed to ensuring that there were safeguards, environmental and social safeguards that would ensure that people are protected and not violated. But the good thing about, some positive about the World Bank inspection panels and all these other adjudication mechanisms is that they heralded citizen-driven complaint procedures, which in a way is a significant transformation of this institution from lawless institutions to institutions that are now open to scrutiny by citizens and communities. So, in terms of jurisdiction of the World Bank inspection panels, this is going to be very short. Their role is to look at cases in which rights or interests have been or are likely to be directly affected by an action or omission of the bank as a result of the failure of the bank to follow its operational policies and procedures with respect to the design, appraisal, and or implementation of projects. So the World Bank inspection panels ensures accountability of the bank for its own projects based on its own internal rules and procedures and standards. not based on international standards or international law. That is a distinction that has to be drawn. So whenever a case is being presented by communities before the panel, the criteria is that the project or the program has violated the World Bank policies, and note that the project is contrary to international human rights standards, for example. Now, you can see that this is an accountability process that seeks the bank's compliance with its own rules and operational procedures. And this logic of compliance with own rules is not a regime of instilling compliance with international law, unless the law complained of arises out of from the bank's operational rules. Now, the procedures of inspection are two. First of all, you file a case before the panel. The case can be filed by communities or members of that communities or civil societies in that area before the panel. So these panels are in every country. Kenya has an inspection panel. So the panel will have to determine whether the case is merited. It receives the complaint from the requesters. So the complaint is filed through what we call requests for inspection. The rules of the panel require that the allegations made by the requesters must contain evidence of violations of a serious character. This implies that the harms must be visible and may have occurred or will occur. That is to say, they are anticipated and knowable. And then once the request has been filed, the panel then decides whether the case has merit. If the case is merited, it submits that request to the executive board for approval, whether they should go ahead with the investigations or not. So you can see in this case, it's the board and not the panel that has got final word on investigations. Now, once granted permission to investigate, the panel will now visit the area for a final study, after which it will do an eligibility report and a recommendation whether to investigate or not. Now, so again here, there is another bar or impediment or requirement that the investigation must meet, that the actual investigation is subject to the board's approval. And you can see this is a very fertile ground for obstruction and avoidance of accountability for the World Bank. Now, at the investigation stage, the chair may assign one or more members of the panel, they're usually three, to conduct the inspection. And while doing so, they are to consult with the bank's various departments and officers, as well as the borrowing country and the executive director of the bank. Now, they will then conduct a fact-finding and submit an investigation report to the executive directors and the management with a finding on the facts, highlighting whether the bank complied with its own rules and policies or procedures. In most cases, these procedures of the World Bank are called operational procedures or safeguard measures or operational directives. That's the name they use mostly. Then the management will recommend what measures to be taken based on the findings of the investigation, which recommendation are sent to the executive board. The board will deliberate on the report and the recommendations and may inform the requesters of their decision and steps to follow. And as in certain cases, they can as well ignore the recommendations of the board, of the panel. So the decision of the panel is not binding at all. Now, those are some of the limitations that I want to discuss at this stage. I don't know whether I still have time. Washington, how much time do I have? Washington?
10 minutes there.
10 minutes to go. Now, these procedures, the fact that the jurisdiction or the powers of the board is limited is a limitation on the autonomy and the independence of the panel. So the panels were created as independent institutions in 1993 when that intense agitation for reform of the World Bank, the way they do their business, was intense. But it seems that they're not actually independent. So they're independent only from far, yet they are far from independent. Now, the panel is merely an administrative body, as you can see, and not a judicial institution. So there's really no real accountability of the World Bank. How would one be accountable to itself? Really, the question is the World Bank really accountable according to this modality or model of accountability? I think not. One can argue that the institutional architecture of the panel offers the bank accountability, avoidance, and obstruction, and to offer functional needs of the bank. Now, Rajagopal, Balakrishnan Rajagopal, has actually really studied how this adjudicatory mechanism of the World Bank evolved. And in his view, this inspection panel system emerged out of the tradition of reporting, the petition system that was there during the League of Nations, that is still very much adopted in terms of human rights implementation and protection. States report, and then the United Nations agency decides what to do with that report. They can act on it or they can ignore it. Like in this case, the board can act on the recommendation of the panel, or they can as well choose to ignore it. But in choosing to ignore, by offering a functionalist need of the bank means that that information is now used as a tool. Remember, information is power, to have some knowledge of people's behaviors and actions in the third world. So Rajagopal argued that the panel seems to him to be much more a tool of information and not grievance redressal. And this, in my view, is what I call politics of manipulated accountability. Yeah, so in the case of Mumbai Urban Transport Project, where you can see the manipulation of politics, is that the panel recommended the stopping of the implementation of the project, but this was resumed within a short period of time because of the board's intervention. The executive board, in which the people who are the controlling powers are European countries and the United States. Now, the other critique is that the decision of the board, the panel is not binding. As I've said, the board has got override powers, which makes the panel a model of overqualified accountability system. In the case of India Development Project of 1988, the panel was limited in its investigation to determine whether the bank's directives had been complied with. In this case, the panel's investigations found a number of violations of the rights of indigenous people who are displaced from the forest, and they recommended further investigation be authorized by the executive directors. Now, however, the board decided that no investigation was necessary in that particular case. So this is what we call manipulated accountability, the politics of manipulated accountability, because the board can decide otherwise. Now, the other critique is that really there's no accountability when that accountability is said to be seeks the adherence to compliance with one's own operational rules and procedures, and not an accountability according to universal standards. So in my view, I think the logic of adhering to operational procedure and policies is so much more a human rights accountability avoidance mechanism for the World Bank, and not instilling or enforcing accountability. Yes, so in the case of Chad versus Cameroon, in this, the question of human rights and governance were raised by the requesters, among other alleged violations relating to social and environmental violations. This case raised the question of where indigenous communities involuntary resettlement between 1994 and 2002, but after full investigation, and indeed the panel found human rights violation, the panel was of the view that it had to consider human rights violations insofar as those allegations, look, this is very, very important, they could only consider human rights violations insofar as those violations would constitute impediments to the implementation of the project in accordance with the bank's policies. Now, what we are saying here is that the bank is not really accountable to international norms and standards. The bank is only accountable externally to communities and digital communities and people, only on the basis of their own rules and procedures. Now, that is to say that one can actually not enforce human rights standards before the World Bank inspection panels, except where those human rights violations are specifically mentioned either as operational directives or operational procedures or certain safeguards. For example, the World Bank had was safeguard against indigenous communities. I think this is a very, very crucial issue. So we can see that the World Bank shirking of human rights obligations or accountability is a political necessity, of course, in the hands of the powerful to operate out of the rules and norms that the international community has propagated for very, very strategic reasons, which we may not go into, geopolitical and geoeconomic reasons, which we may not go into right now. So the inspection panel actually secures for the World Bank real accountability disconnection and accountability avoidance on the fact that there can be no accountability of the World Bank on the basis of international rules and norms and standards. Now, the other critique is that, the argument that is always advanced that, for instance, in the case of International Monetary Fund, some of the policies of these international financial institutions are of a structural nature. They are not of an interactional nature. That is to say that their consequences and impact of a violative nature may not be experienced almost immediately in the implementation of those policies. They may be experienced far much later. For example, the World Bank or the IMF debt sustainability framework may come up with certain structural reforms, for example, on government spending, monetary policies, and so forth, that may hit the country, that may have far-reaching implications like 10 years later or 5 years later. Now, these are not questions that can be subjected to the inspection panel because the consequences are not known. So in my view, I think the violations approach really ignores the question of structural injustices that inhere in the global policy system. That is another issue that we can pick up later. So that is to say that this model of accountability neglects the kinds of violations that are inherent or innate to the kind of global economic patterns that we do have. Now, I have explained that point, the fact that there are certain violations that may be unknowable and their extent or potential are not discernible. For example, in the Lesotho Highlands water project, this was a water project that was being done in Lesotho but was supposed to take water to South Africa. And it was going to disrupt, so there was the end users, some of them who are located in Soweto and in other slums within Johannesburg were going to be affected. Now, this question was taken, of course, before the World Bank Inspection Panel, the question of human rights violations of this project, which did not consider end users, in that it was going to cause a lot of disruption of the supply of water in the slums. Now, of course, the World Bank ignored, the inspection panel ignored this on the basis that those human rights violations were not linked to any of their violations to their internal procedures and directives. Now, the consequence is that, like the consequence of such a water development project in South Africa could not be known at the time, could only be could only be anticipated. Yet, the inspection panel refused to entertain such complaints. The other critique of this complaint mechanism or accountability mechanism is that really the history of the panel is that it emerged as a strategy of de-radicalizing, the politics of de-radicalizing the World Bank. Now, what I mean by that, and these have been quite keenly studied by Rajagopal, who says that the demands for reform in the 1990s that produced internal and voluntary dispute settlement processes had no real intention of creating genuine redress for grievances, and instead, it only served to de-radicalize the third world resistance movement. Now, what this means is that at the time when resistance, subaltern resistance, or resistance to the international development interventions was so intense in the third world, in Africa, in Asia, they had to come up with a mechanism of cooling them down, cooling their tempers. And so if you give them something that a creature that looks like an accountability mechanism, it would cool down the tempers. And indeed, this is what happened. As you can see, the inspection modality is not a genuine mechanism for accountability. It's a half-hearted exercise of the quest for accountability that was given unto the world. Now, in conclusion, I want to state that strategic litigation, in my view, in the area of socioeconomic rights, because suing the World Bank would mean you are enforcing socioeconomic rights of those people that may be violated by these projects, has fundamentally shifted or evolved, moving beyond national boundaries to encompass global development institutions who pose a determining effect to the way in which nation states programs and budgetary policies affect the allocation and distribution of social welfare goods. I think we can see that more and more, as these cases point out in India, Argentina, Brazil, and Malaysia, and even in the United States, have seen their litigation strategies expand enormously. For example, people are now moving to sue the World Bank and IMF in these jurisdictions, as including possibilities that international institutions, including Bretton Woods institutions, the world supremos, can be sued before national courts for various violations. Now, it's therefore my urge to Kenyan legal practitioners that these are not only new frontiers for legal practice, but new terrains for deepening emancipatory struggles and egalitarian forms of justice for the world's poor. I think that is the end of my presentation, and I will take it back to Washington.